It's Monday. Thank you for tuning in to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about securities regulation. Cases that should have gone to the Supreme Court of Canada, but didn't. I know, securities regulation kind of sounds boring, but the case of Christina Dean is very interesting. Miss Dean was a securities regulator. She was working for a particular firm called Hampton. Hampton asked her to add an additional $50,000 to her trading account. This is essentially money that she fronts to cover any potential losses that she might incur in the course of her trading. The reason that they told her to add this money to her account, which was outside the scope of what she had originally contracted for, was because she had losses that exceeded the value in her account at that point in time. Rather than do this, Miss Dean just didn't show up for work. As a result, she was terminated from her contract. And anytime a securities trader is terminated from their contract, a report has to be filed with the securities regulator. In the report, Hampton alleged that Miss Dean had fraudulently traded securities and had incurred losses in a manner that was detrimental to her clients and acted negligently. They essentially marred her reputation on the basis of the report that they filed. She sued, claiming that there was wrongful dismissal, that she was owed money, and that the report was not correct. And ultimately, she was successful in her lawsuit. The Supreme Court of Canada had the opportunity to hear this case and determine what constitutes appropriate reporting. The purpose of securities regulation and regulating securities traders is to protect the public. It's to ensure that people who are having their assets managed by these companies and by these individuals know what they're getting into when they deal with a particular trader or with a particular company. And so these reports are of fundamental importance for the protection of the public. But should there be more oversight in how the reports are made? Should there be more oversight in how statements are reflected on there? And should there be a better opportunity to dispute what's made? All of these are important questions raised by this case, especially by somebody who was ultimately found not to have done what was reported about her and whose career was negatively impacted as a result. The Supreme Court of Canada could have clarified the important purposes of the securities regulator and the manner in which the securities regulator can address issues that come before it, particularly where there are significant serious reports made against individuals. This was a missed opportunity to focus in on an issue that was aimed directly at protection of the public, something that is of national importance, and the Supreme Court of Canada missed that opportunity. Unfortunately, that means it's going to take another case where there is a very serious issue potentially affecting public safety when it comes to securities trading that needs to make its way to the Supreme Court of Canada for this issue to be addressed once and for all. You're watching cases that should have gone to the Supreme Court of Canada but didn't. Thank you for tuning in to another episode of cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.